Today we are here to discuss the NYDFS Cybersecurity regulation as outlined in our most recent guide on cybersecurity and data privacy. I'm Jeff Taft, and joining me today is my partner, Larry Hamilton. Before we talk about the actual regulation, I want to just lay out some basic background so that everybody has that information. The cybersecurity regulation was adopted by the New York State Department of Financial Services almost 2 years ago and will be fully implemented in March of 2019. The cybersecurity regulation has already had a broad impact on the financial institutions that are authorized to engage in business in New York, those so-called covered entities. Even for those financial services companies that are not directly covered by the regulation, the NYDFS cybersecurity regulation has generally raised the expectations of other regulators and defined what are considered best practices for cybersecurity programs in the area. And with that, let me turn it over to Larry to start our program.
Thank you, Jeff. At least annually, the Chief Information Security Officer, or CISO, of each covered entity is required to furnish a written report on the covered entity's cybersecurity program to the covered entity's Board of Directors or equivalent governing body. If no such Board of Directors or equivalent governing body exists, then the CISO's report has to be presented to a senior officer or officers of the covered entity who are responsible for the covered entity's cybersecurity program. The regulation specifically calls out a number of topics that need to be addressed in the CISO's annual report to the extent they are applicable to the covered entity. One is the confidentiality of non-public information and the integrity and security of the covered entity's information systems. Second one is the cybersecurity policies and procedures that the covered entity has in place. A third is to identify and report on material cybersecurity risks to the covered entity. Very important because the whole New York DFS regulation is very focused on the covered entity's own assessment of its risks and tailoring its cybersecurity program to those risks. A fourth item is an assessment of the overall effectiveness of the covered entity's cybersecurity program. And finally, the report is expected to include any material cybersecurity events that involve the covered entity during the time period that's covered by the report. Then, the Board of Directors, or one or more of the senior officers, must on an annual basis, on or before February 15th of each year, submit to the Superintendent of Financial Services a written certification covering the prior calendar year. The certification, which is in a form that's already prescribed by the New York DFS, states that the Board of Directors, or senior officers as the case may be, has reviewed documents, reports, certifications, and opinions of such officers, employees, representatives, outside vendors, and other individuals or entities as necessary, and to the best of their knowledge, the cybersecurity program of the covered entity as of the date of the finding of the board or senior officer complies with the regulation for the year just ended. Notice how the regulation specifically contemplates that the individuals who make the certification will have reviewed documents and opinions and reports from other persons. Let's call those sub-certifications. And therefore, it's important to ensure that those individuals who make the certification have received the information needed to support their certification, including sub-certifications or other attestations from employees who have the direct knowledge and responsibility for the key elements of the cybersecurity program.
A good point, Larry, and I think as we've seen with other certifications, whether it's Sarbanes-Oxley or the like, it typically takes a couple of years for people to get down the certification and the sub-certification process. We saw a number of hiccups, I think, the first time around with people not having those sub-certification processes in place. But I expect as time goes on, people will become much more savvy and aware of what they need to do in order to satisfy that requirement. So I think that's something going forward we're going to see a lot more of. Let me talk now about the breach notification requirements in the NYDFS Cybersecurity regulation. As every company knows, there's a 50-state hodgepodge of data breach notification laws out there right now requiring notification to customers in the event of an unauthorized access to their sensitive personal information. Those laws vary according to the states, and they're very different in some respects. What the NYDFS Cybersecurity regulation imposes is a breach notification obligation where you have to notify the NYDFS of the breach. So under the cybersecurity regulation, you have to notify the NYDFS within 72 hours after becoming aware of any cybersecurity event with a reasonable likelihood of materially harming any material part of the normal operations of the covered entity, or for which notice must be provided to any governmental body, self-regulatory agency, or other supervisory body. So let's take a look at those two requirements there. First, there's a notification obligation if there's a reasonable likelihood of material harm to some part of the normal operations of the covered entity. So if there's something that would disrupt the ongoing process, the ongoing customer-facing activities of the website or something of that nature, you would have an obligation under the regulation, in theory, to provide notice to the DFS within 72 hours or something like that happening. If under some other statute, including the state data breach notification requirements, you had an obligation to notify one of the state attorney generals or to notify one of the federal banking regulators, then you would also have an obligation under that requirement to notify the NYDFS that there's been a cybersecurity event. So those are the two obligations you may have to file notification with the DFS under this statute. As a practical matter, we've seen within the first year of the statute that effectively most companies, when in doubt, have been providing notice to the DFS of a cybersecurity event, not wanting to take a chance that the DFS would say you should have provided notice, and in many cases already providing notices under another statute which would trigger that requirement anyways. In your breach notification plan, you should identify the person or the group of individuals who are responsible for deciding whether an incident is subject to the NYDFS cybersecurity requirement and the notification obligation to the DFS.
And this is, Larry, another possibility is that there may also be other insurance regulatory requirements that require notification, such as many states have requirement to notify the department if there's any kind of insurance fraud that has been committed or is suspected to have been committed. And if the cybersecurity breach includes a kind of fraudulent access, for example, and transfer of funds, then you may have an obligation both to report the cybersecurity breach under the cybersecurity regulation and also a separate correlated fraud reporting obligation. Let's talk for a bit about third-party service provider compliance. Now, this is the last component of the New York cybersecurity regulation to go into effect. There was a 2-year transition period from the time that the regulation was issued in 2017 for the third-party service provider provisions to become effective beginning in March 2019. When that's in effect, each covered entity will have to implement written policies and procedures that are designed to ensure the security of information systems and non-public information that are accessible to or held by third-party service providers. There's been a lot of focus on third-party service providers in the regulatory environment because of the fact that a number of high-profile cybersecurity breaches actually occurred to financial institutions and insurance institutions as a result of the weakness in a third-party service provider's cybersecurity. And that's given rise to the saying that many of you have heard, quoted, that your cybersecurity is only as strong as the cybersecurity of your weakest third-party service provider. So like other policies and procedures that the regulation requires, the third-party service provider policies and procedures need to be based on the risk assessment that the covered entity does and tailored to that risk assessment. Some of the items are actually called out in the regulation as needing to be addressed. A covered entity is required through due diligence or protections in its contracts with third-party service providers to address the following. 1, the third-party service provider's policies and procedures for access controls. Who gets access to the system? And that includes the use of multi-factor authentication, which is one of the topics covered by the regulation itself, in order to limit access to the information systems and the non-public information. Second, the due diligence or contractual protections with third-party service providers need to address the third-party service provider's policies and procedures for use of encryption to protect non-public information in transit and at rest. Third, through due diligence or contractual provisions, there needs to be an obligation by the third-party service provider, or TSP is a term that we often use as an abbreviation. The TSP has to be required to give notice to the covered entity if there is a cybersecurity event in its systems that directly impact the covered entity's information systems or the non-public information of the covered entity that the third-party service provider holds or has access to. And 4, there need to be reps and warranties addressing the third-party service provider's cybersecurity policies and procedures in the contract between the covered entity and the third-party service provider that address the security of the covered entity's information systems or non-public information to the extent that the TSP has access to them. It's really important because of this delegation of access to third-party service providers to make sure that the contracts have these provisions. The reason that 2 years were allowed by the regulation for this part to become effective was to give time in the ordinary contracting cycle, contract renewing cycle, for these provisions to be incorporated. And by March 1st, 2019, it's all in effect.
As Larry indicated, third-party service providers have tended to be one of the bigger weaknesses for most of the financial services companies. That's why it's extremely important that you conduct some due diligence at the outset of your relationship. You get some contractual protections, as Larry said, although the contractual protections, indemnity is not going to get you back your reputation or things of that nature. So contractual protections only go so far. And then the third part is obviously you have to oversee and monitor your vendors once you've signed them up. Simply having a provision in your contract that says you have the right to audit your vendors isn't going to be enough. You're going to have to exercise those rights. And if you find any material weaknesses, you're going to have to make the vendor remediate those weaknesses. Otherwise, those aren't effective provisions within your contract, and your third-party vendors are going to remain a huge risk to you. One other aspect of the regulation that I want to talk about is data governance and classification. Every cybersecurity program should have some means of addressing data governance and classification. This seems like a relatively straightforward issue, but it is really one of the linchpins of having an effective cybersecurity program. If you don't know where your information is maintained and you don't know what information is important or what information should be subject to higher levels of protection, then you're not going to be able to really have an effective cybersecurity program. Covered entities must implement a framework that's designed to ensure that non-public information is identified and protected by the cybersecurity program. Because of this, oftentimes now when you receive emails from outside financial services organizations, they may designate, for example, within that email that this is confidential, highly confidential, or public information within that email. This is just one way that institutions are going about data classification. It's a very common feature that we're seeing in a number of large financial institutions now, and even some of the smaller institutions are making that change and that improvement in their process. That's a key element, obviously, again, for one to identify whether the information is in fact confidential. Proper classification within the organization, i.e. public, confidential, highly confidential, is another element of data security, as providers, senders, and recipients of such information will need an immediate understanding of the sensitivity of the data they are handling. It's not always readily apparent to people whether the information they're handling is, in fact, private or confidential information. Some of them may feel that this is information that's widely known within the company or widely known outside the company, but in fact it's not. It is highly confidential information. So any attempt to label that information internally is a step in the right direction of helping employees understand the classification of that information to which they come into contact with. Also, by classifying information, one thing you can do is you can limit access to that information by classification. Oftentimes we talk about people who have a need to know the information, have access to that information, but that entails some sort of a classification system where access controls are based upon the classification of the type of information that's being maintained by the company. Without classification, it's very hard to tailor your access controls to that specific type of information, such that you may not be able to preclude people from accessing information that's highly confidential unless you have access controls that limit access to that information to certain identified individuals.
The New York cybersecurity regulation requires each covered entity as part of its cybersecurity program to provide regular cybersecurity awareness training for all its personnel. In addition, the regulation expressly requires that training to be updated to reflect the specific risks that the covered entity has identified in its risk assessment. By now, that refrain should be quite familiar, that the requirements of the regulation are tied to the risks that are developed and identified in the risk assessment. Needless to say, training of employees and vendors is a very important aspect of any cybersecurity program. We already mentioned the third-party service providers as a potential source of breaches and other cybersecurity incidents. The same applies to employees, who are frequently the gateway through which the cyber breaches occur. Many of the breaches that have come from phishing, spear phishing, and other third-party attacks could have been avoided by targeted training that prepares employees to look out for the very common phishing and spear phishing techniques. And the harm from successful attacks could also be mitigated by conducting tabletop and similar training exercises to test the response plan after an incident has occurred. The training needs to relate to the particular risks, and it's not enough to just give a generalized training of how to use your technology. That's part of the employee standard onboarding process, but rather exercises, and I'm sure Jeff can talk about this as well. I think many companies are now resorting to tests where they themselves do the phishing effort to test their employees and see how many of them succeed or fail. The statistics that come out of those tests are really quite amazing, that despite a lot of preparation, there's still this enormous tendency to click on the link to get the free Walmart gift card. And so the training is not a once and done kind of exercise either. It's an ongoing one.
That's a really good point, Larry. I think one of the key things about cybersecurity training is that it always has to constantly be evolving. Part of that is because the threat actors are always changing, and quite frankly, the attacks are changing on a regular, ongoing basis. The phishing attacks we see today are far more sophisticated than anything we saw 2 or 3 years ago. And again, they're designed to trick employees, and they still do a very good job of it, despite the fact that there's ongoing training that's being provided. And as you said, ongoing testing of employees. Many employees now who click on those test links find themselves in some sort of remedial cyber training for a couple of weeks or a couple of months afterwards in order to basically remedy that situation. As Larry said, cybersecurity training is extremely important because, as we've seen in our practices, most of the breaches that we've come across have been because of employee errors, or the errors resulting from vendors not being properly trained in the company's cybersecurity policies. Training is a direct way of limiting the potential for cybersecurity breaches. It's not going to eliminate them, but it's certainly going to mitigate those likelihood of having a breach. And even if there is a breach, as Larry said, you're likely to mitigate the effects of that breach by properly training your employees. We spent most of our time today talking about the NYDFS Cybersecurity regulation, but I think it's also important that people understand that there are other state law requirements out there that exist today, and there are likely to be other state law requirements on the horizon that are going to be adopted in the near future. States have proven in the privacy and cybersecurity area to be the laboratories where they're adopting regulations where they perceive there to be a shortcoming at the federal level. After the NYDFS adopted its cybersecurity regulation, the National Association of Insurance Commissioners adopted an insurance data security model law. That model law was adopted in May by the first state, South Carolina, and other states are expected to follow. But it's not just in this insurance industry. We see it in other areas, obviously, where states are adopting cybersecurity requirements. Even if you go back several years, Massachusetts obviously has a cybersecurity regulation that imposes requirements on companies handling customer information and also how they handle that information with their vendors. With respect to the NAIC's model law, while the model law requirements have a strong similarity to the NYDFS cybersecurity regulation, there are also some differences, particularly with respect to the insurance industry-specific structures and practices. Nevertheless, insurance licensees can leverage these steps that they've taken to comply with the NYDFS cybersecurity regulation to achieve compliance with the model law's requirements.
That's a good point, Jeff, because actually when the model law was adopted, there was a provision in there called a drafting note that indicated that compliance with the New York DFS cybersecurity regulation would be deemed to satisfy the requirements of the model law. Exactly how that gets implemented is still unclear, but definitely everything that's being done to comply with the NYDFS regulation will be materially advancing compliance with the NAIC insurance data security model law. And admittedly, that law has been a little slow in gaining traction. So far, only one state, South Carolina, has enacted it. There was legislation in at least one other state this year to enact it, but that has not passed yet. But we expect to see in 2019, the legislative sessions, a very substantial array of bills in the state legislatures to adopt the model law. And hanging over all of this are some statements that have been made by the Federal Reserve indicating that if the states don't adopt the model law within a few years, it could well be that the federal government will decide to step in and enact, through its preemptive authority, some kind of cybersecurity regulation similar to what the model law and the New York DFS regulation do. So it's coming to a state near you, and regardless of whether you're in New York or someplace else, if you're licensed in New York, the DFS regulation is already applicable to you. Very important to focus on all these issues we've discussed today.